Maine Tenants Justice League presents The Truth About Evictions, narrated by Gina, with special thanks to Pine Tree Legal Assistance. Their website can be found at ptla.org. Legal Information Disclaimer. The creators and presenters of this legal presentation are not lawyers. The creators and presenters of this legal presentation have no legal liability for any results you have by applying this legal information to your own situation. This presentation is for education and entertainment purposes only. Legal information offered in this presentation is not legal advice. Legal advice requires application of legal information to individual situations. Contact a legal clinic or lawyer in your area if you need legal advice. Maine laws reflected in this presentation are current as of February 10, 2017. Important question. Do you have legal title to the property? Tenants never legally own or hold legal title to their home, so they will always technically lose an eviction hearing. The court only wants information about which person has the legal right to have physical possession of the property. If you own a mobile home and rent your lot, Maine has special rules landlords must follow to evict you from the land. Check your local rules and laws for laws in your area. If you live in a condominium, Maine has special eviction rules. If you rent your home from your employer, they may be able to go to court to evict you without first giving you written notice to quit. Get legal advice from a local attorney or legal clinic. If you live in a hotel, you do not have a right to an eviction hearing in Maine. The hotel can have you removed by police with little notice. Important thought. The only victory the tenant may enjoy is more time to move. The legal truth. All mortgage loans, real estate property taxes, and rental payments are actually rent payments made to the owner of the property for the legally revocable privilege of living on their land or in their building for a period of time at the owner's convenience. If you are a homeowner with a mortgage loan and real estate taxes, you have no legal right to possess the house and land where you live until you pay the mortgage loan in full or get a mortgage discharge and obtain a allodial title on the land. If you are a homeowner who does not have a mortgage loan, but you pay lot rent to an individual or real estate taxes to the town, you have no legal right to possess the land where your home sits. Your only possessions are the debt-free buildings and structures on the land. If you are a tenant who pays rent to an individual or corporation for your home, you have no legal right to possess the unit, building, or land where you live. If you are a resident of a hotel, motel, or other establishment that rents rooms on a daily or weekly basis, which provides cleaning and other services, you are not a legal tenant in Maine and are not allowed to have a trial under eviction laws. The hotel or motel has a legal right to forcibly eject you with only a few minutes' notice and by use of police force if necessary. Introduction. The purpose of this presentation is to teach you how to defend yourself against an eviction lawsuit without hiring a lawyer in Maine state courts. Legal fact. Maine Judicial Branch's annual reports fiscal year 2010 to fiscal year 2015 show a 30% spike in statewide evictions, otherwise known as forcible entry and detainer cases. In 2010, there were 4,717 cases. In 2015, there were 6,177 cases. Legal fact. Maine Judicial Branch's annual reports, fiscal year 2010 to fiscal year 2015, show no tenants have been allowed to have a trial by jury for any eviction cases. So what can you do if your landlord is trying to evict you? Lesson 1, what to do first. Lesson 2, you are being evicted for non-payment of rent. Lesson 3, what does the landlord have to do to evict you? Lesson 4, what if you want to move anyway? Lesson 5, how much time do you have to move? Lesson 6, you want to fight the eviction. Lesson 7, what happens if you don't move? Lesson 8, you can't find a lawyer to represent you. Lesson 9, what happens when you go to court? Lesson 10, what happens during the court hearing? Lesson 11, what if you lose? Lesson 12, can you be evicted in the winter with children? And Lesson 13, can you appeal? And final thoughts. Maine laws are presented in this presentation. However, basic legal principles apply to evictions in every state. Check your state laws and rules for recent changes. Rules of procedure control all court proceedings in every state, and there is no legal excuse for ignorance of the law. As you know, they say, ignorance is no defense. The statistics nationwide, with little variation from state to state, show that 99% of landlords have lawyers, but 99% of tenants do not have lawyers. So when tenants and landlords go into court, landlords almost always have a lawyer with them, whereas tenants are standing alone and scared, not knowing what to do. However, even if the landlord has an attorney with him, all facts and evidence must be offered and authenticated by the client, which is the landlord or yourself, and their witnesses. Lawyers cannot enter facts or evidence into a court record unless he has personal first-hand knowledge of those facts. However, if the lawyer has personal first-hand knowledge of the facts of your case, that means the lawyer has become a witness to your case and can no longer be an attorney for the case. Lawyers can talk about only laws and procedures in court. If the client does not know the rules of procedure, the client has no ability to know if the lawyer makes legal mistakes that may damage the client's case. Legal clients are legally responsible for all actions taken by their attorney. Lesson 1. What to do first. Are you being evicted for non-payment of rent? Did you withhold your rent for unsafe conditions? Does your landlord make other allegations against you, such as being a nuisance, playing loud music, making damage to the property? Do you have a term lease for 6 months or a year? Or do you have a month-to-month at-will agreement? Do you need emergency rental assistance to stop the eviction? Is the property safe, clean, and habitable? Do you want to move? Can you pay your back rent or enter a payment plan? Call your landlord or his attorney to try to settle the case or make a payment plan with him. If your landlord won't settle with you, he must take several steps to legally evict you. You have at least 2 weeks in Maine beyond the end date stated in the first notice to quit to move. Before agreeing on a move-out date, read lessons 5 and 6. If you want to fight the eviction, do you have valid defenses? Read lesson 10 for possible defenses you can use. Can you afford to pay a private attorney? Can you afford to pay all necessary court filing fees and other costs, such as printing, postage, copying, and travel costs for your witnesses? Can you get a waiver of filing fees because you have low income? Can you read and understand legal documents? Can you write your own legal documents? Do you have someone to help you write your legal documents? Can you respond quickly to short deadlines to file legal papers? Can you and your witnesses attend all scheduled court hearings? Do you have difficulty speaking in public among a lot of people? Are you prepared to spend several months fighting the eviction? Important points to remember. Do not ignore any legal papers. Read all legal papers you receive at least 3 times before replying, if a reply is necessary. Make notes about all the mistakes in the landlord's or the court's legal papers, including the spelling of your name, the unit number that it states that you occupy, the physical address, the date that you were served, the date the court hearing is scheduled, and other mistakes. Call your landlord or his attorney to try to settle this case out of court. Read Maine Rules of Civil Procedure Rule 80D about evictions, or appropriate rules of procedure for evictions from your state. Print the rules of procedure to bring to court with you. Put them in a 3-ring binder and have them available. Print all the letters, legal documents, emails, text messages, photos, and other documents for court. Go to every scheduled court hearing and do not be late. Bring all the legal documents, evidence, and witnesses to every court hearing. Bring enough money to pay any or all back rent you may owe your landlord. Start looking for another place to live immediately. If eligible, apply for emergency rental assistance programs in your area. Start gathering boxes, packing your items, and moving your possessions that you don't need to use immediately. If you have a legal disability or don't speak or read English very well that prevents you from reading or understanding the laws and rules, you need to notify the court as soon as possible so the judge will make reasonable accommodations for you to participate in your court hearings. Sometimes asking for reasonable accommodations can delay the court hearing so the court can have the proper translator or item available for you to use. You must understand that the rules of procedure are not the laws. The rules of procedure outline the way you enforce your rights under the laws, which are the statutes, and the constitutional protections, which control the statutes. The rules and the laws are always changing, so you must do your own research in your own state before you attempt to respond to any legal papers. The law is based on words, so always be careful what you write. The smallest mistake can make huge legal problems and can get a case dismissed. Every lawsuit is won or lost by the paperwork filed by each party. Lawsuits are based on the quality and weight of facts and evidence, which must be filed with the court. If you don't show evidence, you will lose your case. If you know you will lose, why go to court? Because you have a legal right to have a court hearing before you lose your home. Every eviction action must follow due process, which means proper procedures. If you go to the eviction hearing, you may be able to get a month or more to move out. If you do not go to the eviction hearing, you will have about 10 days or less to move before police will arrest you for criminal trespassing. The landlord must go through the proper legal process that is due before he can regain physical possession of his private property. If your landlord does not follow due process of law during your eviction, will you win the case? No, because you are not the legal owner of the house or land where you live. Lesson 2. You are being evicted for non-payment of rent. Ask your landlord if he will accept a payment plan so you can pay your back rent. If he will not agree to a payment plan, you may be able to get help from a community resource agency in your area. Housing and Urban Development offers links to local state rental assistance programs at the link shown on your screen. In Maine, you can check with these agencies. Family Crisis Assistance Program used to be known as the Emergency Assistance Program, run by Department of Health and Human Services. It provides emergency help only to low-income households with children. You can get up to $250 for housing emergency and apply this toward a security deposit or back rent if it will prevent the eviction. However, your landlord is required to accept the $250 and withdraw the eviction. So if he will not agree to accept the $250 to stop the eviction, Department of Health and Human Services most likely will not give you that help. Another program is Alternative Aid, also run by Department of Health and Human Services, which helps only families with children. It provides the equivalent of 4 months of TANF benefits to resolve emergencies, such as an eviction, that may prevent you from getting or keeping a job. General Assistance is a welfare program run by every city or town. If your income is too low to meet your basic necessities, such as rent, and your income is less than the maximum allowed, your local town should be able to assist you, whether or not you have children. However, be warned, in the state of Maine, particularly in the Augusta, Maine area, the maximum monthly income that you are allowed to have if you have housing, not subsidized housing, but if you are living in a home that you pay rent for, your income cannot exceed $450 to receive general assistance. If you are homeless and do not pay rent, your income must not exceed or go over $425 per month to get general assistance. Salvation Army or Red Cross may be able to help you with emergency housing if you cannot get any kind of financial assistance to prevent you from becoming homeless. If you cannot get any community support, you may be able to delay or prevent the eviction by officially filing for bankruptcy and claiming your rent as debt and your landlord as a creditor. Did you report unsafe conditions to a government agency, such as code enforcement officer or fire department, before getting your notice to quit? Did you ask your landlord to make safety repairs to your unit before he gave you a notice to quit? Did you withhold rent because of unsafe conditions in the building before you received the notice to quit? Did you save your rent in case you were evicted for non-payment? Try to reach an agreement with your landlord to pay your back rent. Save as much of any of the withheld rent to prevent the eviction or to move. Save all receipts for all materials you bought to fix unsafe conditions that you or your guests did not cause. A notice to quit is not the same as a court order. A landlord cannot force you to move without a court order and a writ of possession. Lesson 3. What must the landlord do to evict you? Your landlord must give you a written eviction notice, and it must have certain statements in that notice. The type of notice depends on what type of tenancy you have. If you do not have a written lease, the notice to quit will tell you if you have 7 days or 30 days to move. Save the notice. Your landlord cannot legally change the locks, shut off your utilities, or try to keep you out of your home in any other way. Call the police, a legal clinic, or a lawyer if your landlord tries to evict you without a court order. When the notice to quit expires, the landlord can have you served with the official court papers by civil sheriff deputy. In Maine, the sheriff must try 3 different times on 3 different days to personally serve you in hand with the summons and complaint. On the 3rd day, the sheriff can post the papers on your door. The landlord must file an affidavit with the court swearing to the steps he took to notify you about the eviction hearing. If you want to delay the eviction, you have no legal obligation to open the door for the sheriff when he comes to try to serve you with the summons and complaint, nor do you have any legal obligation to open the door when your landlord serves you with a notice to quit. Both the landlord and the sheriff are required to try 3 different times on 3 different days to personally serve you in hand with the notice to quit and the summons and complaint. So if you choose not to open the door for the landlord and the sheriff on those days, you will be able to buy yourself 6 full days until the court hearing, whereas if you open the door for them on their first try, you would be depriving yourself of 4 days to live in the property before your hearing. If you have a written lease for a period of time, such as 6 months or a year, your landlord can evict you for a material breach of the lease, which means you violated a major duty under the lease, such as payment of rent, not disturbing other tenants in the building, not causing major damage, or some other material lease clause. Read your lease carefully so you know exactly what you agreed to and what allegations your landlord is making against you are true. If you have materially breached the lease, your landlord can serve you with a 7-day notice to quit. The notice must advise you of your right to contest the eviction in court. If your lease has come to the end of its term, in Maine, if your lease does not say it renews automatically when the lease term ends, your landlord can go to court without giving you any notice. But he can only do this during the 7 days following the end of your lease term. So that means if your lease expires on December 31st, then he can go to court the first week of January without giving you any notice, but he cannot do it the second week of January. If your rent is subsidized through Housing and Urban Development or another subsidy agency with a written lease, it probably renews automatically, so this clause does not apply to you. If you are a tenant at will with a month-to-month agreement, your landlord must give you either a 30-day notice to quit or a 7-day notice to quit, or he can combine both of those into one notice. Your landlord can evict you with 30 days notice for no reason, but a 7-day notice must be specified the reason. Any notice must advise you of your right to contest the eviction in court. In Maine, the notice must not terminate the tenancy until the last date for which your rent has been paid or later. For example, if your rent is paid through the end of June, your notice period cannot end before June 30th, and the notice must give you a full 30 days. So, if your rent is paid through the end of June, then the landlord must serve you with a 30-day notice by the last day of May. If the notice does not follow these rules, you may be able to stop or delay the eviction. If you can, get legal advice. The landlord or his agent must give you a notice to quit in person, with the exception that the landlord or his agent must make 3 good faith efforts to hand deliver the notice to you. If he cannot find you after 3 tries on 3 different days, he can mail you the notice and leave a copy at your home where you will find it, most likely posted on your door. In Maine, to evict you with a 7-day notice, Your landlord must state that reason in writing, which must be one of these: you have seriously damaged the apartment and have not repaired the damage. You have been a nuisance to other tenants or neighbors. You have made the apartment unlivable or unfit to live in. You have changed your door locks and have refused to give your landlord a duplicate key. Or if you are 7 days or more behind in rent, if the reason is that you have not paid your rent, then the notice must include these two sentences. Quote, if you pay the amount of rent due as of the date of this notice before this notice expires, then this notice as it applies to rent arrearage is void. Close quote. Second sentence. Quote, after this notice expires, if you pay all rental arrears, all rent due as of the date of payment, and any filing fees and service of process fees actually paid by the landlord before the writ of possession issues at the completion of the eviction process, then your tenancy will be reinstated. Close quote. You can usually stop an eviction by paying the rent you owe if the landlord does not make any other allegations. If you do not pay what you owe before your next rent date, you have to pay both months' rent to stop the eviction. If overdue rent is the only claim, you can stop the eviction by paying all rent owed even after the landlord takes you to court. But you have to pay all rent due and the landlord's court costs, including cost of serving the court papers and court filing fees. Your last chance to stop the eviction is just before the court issues the writ of possession. Your landlord can get a writ of possession 7 days after he gets the court order. Lesson 4. What to do if you want to move. If you want to move but cannot do that before the landlord can get a writ of possession from the court, talk to the landlord or his attorney about agreeing to extra time to move. The landlord is not required to agree to this. Remember, you already have 7 days after the court hearing before a writ of possession can be issued. So if you settle with your landlord, make sure you get more than 7 days after the court date. Once you agree to a date, the landlord can get a writ from the court on that date and have it enforced by a sheriff. It will be too late to change your mind after a judge approves the agreement. If you make an agreement after court papers have been filed, have your landlord sign an agreed judgment form to protect your rights. Indicate the move-out date you've agreed to and any other agreements. Fill out the form, sign it, have your landlord sign it, and file the original copy with the court. Keep a copy for yourself and give a copy to your landlord. Make sure everything you agree to is in writing to prevent any confusion. Make sure you go to the hearing to give the agreement to the judge. If you know for sure you will move before a writ of possession will be issued, the legal eviction process will not affect you. You may want to tell the landlord about your plans to save him the trouble of going to court to get an eviction order, because he can sue you in small claims court to recover all of those legal costs. Be absolutely sure about your plans to move if you decide to ignore the court eviction hearing. It will be too late to fight the eviction after a court judgment and writ of possession is entered against you. Lesson 5. How much time do you have to move? You are not legally required to move until the following events have happened. Check your local rules and laws for proper times. First, the notice to quit must be properly written and served on you. Second, the time period in the notice to quit must expire, usually 7 full days or 30 full days. Third, you must be served with court eviction papers, which would be the summons and complaint, by sheriff, which must give you at least 7 more days before the court hearing occurs. Fourth, if you lose the hearing and do not appeal, you will have 7 more days to move. Fifth, after 7 days, if you have not moved, you can be served with a writ of possession by sheriff. You then have only 48 more hours to leave. Lesson 6. you want to fight the eviction. Usually, the notice of a court date gives you a short time to prepare, as little as 7 days. Check your local rules and laws. If you can find a lawyer quickly enough, provide this information to your lawyer as soon as possible. Your eviction notice, your lease or rental agreement if you have one, written reports or complaints you've made of unsafe conditions, written requests you've made for repairs, rent receipts and other evidence of payment if the landlord is claiming you did not pay your rent, and the summons and complaint. You can expect to spend at least $3,000 or more on legal services for a private attorney to fight your eviction, not including all court filing fees, copy fees, and printing and postage costs for your legal filings. Your final legal bill can easily exceed $10,000. If you hire a private attorney to defend you, you are responsible for everything the attorney files and does not file into court. The attorney is acting on your behalf, but he cannot speak for you. Important note: you and only you are responsible to recognize and correct all legal mistakes your attorney makes while defending your lawsuit. If he makes mistakes which you do not recognize or correct, it may very well lose your case for you and you will not have any appellate rights. You are required to pay all court filing fees for every document filed into court unless you are granted a court waiver, which you can request by filing an application to proceed in forma pauperis with an affidavit of income and assets showing your household income is at or below federal poverty levels. Even if the court waives your payment of court filing fees, you are still required to pay all legal and other fees charged by your attorney. If you hire an attorney but cannot pay your legal fees, your attorney can legally withdraw from your case because you cannot pay his fees. The attorney's withdrawal from your case will not stop due process from continuing according to rules of procedure. If you cannot find an attorney or someone else to help you file the proper papers at the right time, you will lose your case and your right to appeal any court orders entered against you. If you find a good attorney who files all the right paperwork at the right time, and you always pay your legal fees, you will still lose your case. Why? Because you do not legally own the property you are renting. Lesson 7. What happens if you don't move? A civil deputy sheriff will serve you with a summons and a complaint. The summons will tell you the date, time, and place of the hearing. You must get the papers at least 7 days before the court hearing. Seek legal advice immediately. If you go to the hearing without a lawyer, ask for a recorded hearing. Send a letter to the court 24 hours in advance to ask for a recording, and then ask again when you get to court. You must go to the hearing. Do not be late. The judge will order you and your landlord to first attend mediation if you're in Maine. If no agreement is reached during mediation, you will have a full trial. Lesson 8. You can't find a lawyer to help you. If you cannot find a lawyer to represent you at the eviction hearing, Pine Tree Legal Assistance and other legal clinics have forms to help you fight your eviction. Download, complete, and print these documents from Pine Tree Legal Assistance website. A form letter to the clerk, and a form called Answer Affirmative Defenses and Request for Electronic Sound Recording. Check your local legal clinic for similar forms, or use these forms and change the court information to identify your local court. Call your local court every day to ask if your landlord has filed the complaint with the court. You cannot file any papers into the court until the landlord files the complaint and opens the case. In Maine, the landlord does not need to file the complaint until 24 hours before the date and time of your eviction hearing. You cannot get any subpoenas to serve on your witnesses until your landlord opens the case by filing the complaint with the court. Rules of procedure require your witnesses be given a certain amount of time to prepare for the hearing and gather requested documents. You are required to pay your witnesses for their travel expenses as calculated by the court at the time you have them served with a subpoena. Under Maine Rules of Procedure, if you want to subpoena a witness, you must buy a subpoena from the court for the eviction case, fill it out properly, have it served properly by someone other than yourself, pay your witness for their time and travel as required by the rules, give witnesses enough time to gather and organize evidence they need to bring with them, and make arrangements with their job and family to attend the court hearing, and give witnesses the required 7 to 14 days advance notice to attend. A witness is not required to appear at a hearing if they are not properly served with a subpoena. As you can see, under Maine rules, it is impossible to subpoena any witness for an eviction case if the landlord does not file the complaint until 24 hours before the court date. If you do not have any witnesses at court to testify about the facts of your case, you will lose your case and will not have important facts in the record for an appeal. So how do you win your eviction case without witnesses? You don't, unless you have video and audio evidence to submit to the court. But that evidence must be authenticated by the witnesses on the recordings. As you can see, preparing for and winning an eviction case in Maine is difficult because the laws and rules that control rental housing conflict with rules of procedure. Hiring an attorney will not change the laws and rules. Tenants do not own their homes and will always be evicted, no matter what they say or do. Step 1. Complete the letter to the court. Fill out the date, the address of the court, name of the case where it says R.E. colon, for example, R.E. colon Smith v. Jones. Sign your name, include your address, and your phone number. Step 2. Complete the form called Answer Affirmative Defenses and Request for Electronic Sound Recording. Include names of the plaintiff, which would be the landlord, and the defendant, which would be you and anyone else named as defendant. Fill it in just like on the complaint that was served on you. Fill out the name of the court just like your landlord did. And on the answer at question 3, check the correct box. On the affirmative defenses, check all boxes that apply. A list of some common defenses are included in the form. Add any defenses you have that are not listed, and you can include any violations of the rules that are described here. Fill in the date, sign it, and include your address and phone number. Step 3. Make 2 copies of both papers, one for yourself and one for the landlord. Step 4. Send copies of both papers to your landlord. If the summons on the lower left-hand side lists the name of an attorney, send copies of everything to the attorney instead of the landlord. Step 5. On the original answer, sign and date the certificate of service. This shows the court that you have notified the landlord of your answer. Step 6. Send the original letter and original answer to the court clerk. The clerk's name and address is on the summons which was served on you. Try to get this to the court at least 1 day in advance. You may not be allowed to get a copy or transcript of the hearing recording if you need it later for an appeal, unless your request for sound recording was made at least 24 hours before the hearing. Lesson 9. What happens when you go to court? You must go. Don't be late. And bring all witnesses, videos, audios, photos, emails, text messages, and letters with you. Bring a device to play your videos and audios into the court record. Make sure you print off the photos and text messages to give to the court for the court record. When you get to the court, speak with your landlord or his attorney about settling the case. In Maine, you will be sent to mediation before a court trial is held. You must mediate in good faith, but you don't have to agree to anything you believe is wrong or unfair. If you reach an agreement during mediation, the mediator will put the agreement in writing and have you and your landlord both sign it before the judge signs it as a court order. If you do not reach an agreement during mediation, you will have a trial in front of the judge. If the court docket has a lot of cases to be heard on that day, you may be lucky enough to have your case rescheduled for the next eviction date, which will buy you at least another week or more. But if you don't appear at the hearing, you will lose by default because you didn't attend the hearing or object to the eviction. Lesson 10. What happens during the court hearing? If you and the landlord do not settle the case, there will be a hearing. Ask for the hearing to be recorded, which you should request in writing at least 24 hours before the trial. All parties and witnesses will be sworn in by the judge or court officer. The judge will ask the landlord to tell his side of the story first. After the landlord presents his case, you will be able to ask him questions. It's a smart idea to write a list of questions before you get to court so you know what you want to ask him before you get there. You can ask follow-up questions to clarify his earlier statements, or you can discuss information he has not talked about yet. He may present other witnesses. You can ask them questions too after they have finished telling their stories. When it's your turn to testify, tell the judge your story as clearly and simply as you can, with as many details and facts as possible, and present evidence to support those facts. Tell the judge the reasons you raised in your written answer about why you shouldn't be evicted. The trial is the proper time to tell the court your side of the story, submit your evidence, and have your witnesses testify. If the other cases being heard before yours take too long, and if you have a lot of witnesses to testify, you may be able to delay your trial for another week or more if you attend the hearing and are prepared for trial with evidence and witnesses. The court is required to provide you with due process of law, which means giving you a fair opportunity to present your evidence and witnesses without being rushed for time. You also have a right to ask your landlord and his witnesses as many questions as you think are necessary to defend yourself or discredit what his witnesses have said. When you ask witnesses questions is the proper time to ask the witness to authenticate the various pieces of evidence, and then you ask the court to enter the evidence into the record as an exhibit. Some common arguments you can use against the landlord include: you did not receive the notice to quit, the notice to quit did not give you 7 days to pay your back rent, the notice to quit said you have 30 days or 7 days before the tenancy ends, but it really gave you less than 30 days or 7 days after you received it. The 30-day notice period runs out while your rent is still paid up. The landlord is trying to evict you only because you complained to a code enforcement officer or to the landlord in writing of unsafe conditions in the apartment. Or the landlord is trying to evict you for other illegal retaliatory reasons. Another common argument you can use is you did not pay rent because of unsafe conditions, which makes the house unsafe or unhealthy to live in. You told the landlord about these problems, but he has not fixed them. If you win on this point, the court can set a lower rent, which you must pay until the needed repairs are done. If you have a legal disability and need a reasonable accommodation so you can continue living where you are, your landlord, for example, may not like your housekeeping. So if you could get set up with a housekeeping service from a social service agency, you could both be satisfied with the solution and he would have no reason to evict you. The landlord's story that you are behind in rent, caused a nuisance, or broke the lease is not true. State the facts on these issues based on your own knowledge. If there are witnesses who can verify your version of the facts, You must bring them to court and ask them to testify about what they saw and heard. The 7-day notice you got for non-payment of rent does not contain the 2 sentences stated previously. If any of those defenses apply to your case, be sure to tell the judge. Improper notice defense. Your landlord must follow all of the notice rules, which were explained above. If you think your notice to quit did not meet all of the rules, explain your reasons to the judge. If the judge finds your landlord did not follow all of the notice rules, then the landlord loses and he will have to start the eviction process all over again. Unsafe or unfit housing defense. If your landlord is trying to evict you because you owe back rent, you may be able to stop the eviction if you didn't pay rent because of serious problems with your home, which the landlord refused to fix after you gave him proper notice. This is called a warranty of habitability defense, because the landlord has broken his promise to rent you a safe home. If the judge decides the landlord has not fixed serious problems, which you can prove you told him about, you can ask the court to let you out of your lease or to let you stay and pay a lower rent until the landlord makes your home safe. If you stay, the judge will also decide how much back rent you must pay at the lower rate. Retaliation defense. There are laws to protect you if your landlord tries to evict you because you asserted your rights. If you can show proof your landlord is trying to evict you because you complained to the city about serious code violations, asked your landlord in writing to do necessary repairs, filed a fair housing discrimination complaint with a government agency, are the victim of domestic violence, sexual assault, stalking, or started or joined a tenants union, then the judge should not let the landlord evict you. The law only allows use of the retaliation defense if you withheld your rent because of unsafe conditions. The discrimination defense. Your landlord cannot evict you because of your race, color, sex, sexual orientation, physical or mental impairment, religion, ancestry or national origin, getting welfare, or because you're a single parent, pregnant, or you have children. Reasonable accommodations are required. If you or someone in your family has a physical or mental impairment which substantially limits your daily activities and need a reasonable accommodation to allow you to fully use and enjoy your unit, most landlords must allow for reasonable accommodations to help you stay in your home. You can ask for reasonable accommodations even after you get an eviction notice. A court should not allow your landlord to evict you if your landlord has not tried a reasonable accommodation. Try to get a lawyer to help you with this defense. Lesson 11. What if you lose? You use the rules of procedure to buy more time. Even though you will eventually lose the eviction on the merits or facts of the case, because you do not own the property, you can win more time by applying rules of procedure to your advantage. In Maine, you are not allowed to demand a trial by jury until after you lose the first eviction hearing, and only if you disagree with the facts your landlord tells the court about your rent or other tenancy issues. Even if you disagree with your landlord about the facts of the case, if you do not own the building or land he is evicting you from, you will eventually lose the eviction. If you have a trial and the court orders the eviction, you will have about 9 days to move, 7 days plus 48 hours. If you disagree with the facts offered by your landlord, you may be able to appeal the eviction to Superior Court to have a trial by jury. If you believe the judge made an error about the law, You may be able to appeal the eviction to Superior Court for a bench trial about the laws. Remember, if you are being evicted only for not paying rent, you still have the right to stay if you pay all back rent plus the landlord's court costs before the court issues the writ of possession. Your landlord may have more than one reason for trying to evict you. Even if you have a good defense to one of his complaints, the judge may still allow the eviction if the landlord has another good reason why he wants you to move out. Lesson 12. Can you be evicted in winter with children? Yes. Maine law allows your landlord to evict you any time during the year, even if you have children, but you cannot be evicted because you have children. If you are being evicted because you have children, call Maine Human Rights Commission or your local Human Rights Commission to file a complaint. Check your local rules and laws for current information. Lesson 13. Can you appeal? Yes, you can appeal your case to Maine Superior Court if you believe the court's decision was wrong based on factual evidence, or if the judge made procedural errors or violated a constitutional guarantee. Be prepared to pay all alleged back rent and future rent to the landlord or into a court escrow account with your notice of appeal, and during the entire time your appeal is pending. There is a strictly enforced appeal deadline of 7 days or 30 days. An appeal must be filed before the writ issues or within 30 days. The writ cannot be issued until the 7th day, so file the appeal with the district court within 6 days of the day the judge signed the eviction order against you. The absolute deadline is 30 days from the date of judgment if a writ of possession was not issued before you filed the appeal. On appeal, you can have a new trial with a jury about the facts, if Superior Court allows you to have that new trial. To get a jury trial in Superior Court, you must prove to the court in your notice of appeal that you and your landlord disagree about the facts of the case. If you only disagree about what the law means or how the judge applied the law to your case, the appeals court will only review the record of your first hearing to see if the judge made any legal mistakes in deciding the case. If you do not ask for your eviction hearing to be recorded, the appeals court will not have a record to review and will dismiss your appeal. After you receive a copy of the eviction order at the end of your trial, go to the clerk's window and ask for the following forms, or print them now and have them filled out before you arrive at the courthouse. Notice of appeal and affidavit for forcible entry and detainer, application to proceed without fees, affidavit in support of your application to proceed without fees, transcript and audio order form, and motion for transcript at state expense. You must file all of these forms within 7 days of the date of your hearing to delay the issuance of the writ of possession, preferably by the 6th day to be safe. It is a good idea to file a motion to stay issuance of the writ of possession with these forms so the court knows you want to delay the writ of possession. In Maine, the court will probably deny your appeal, but that's not what you're trying to do. You are simply trying to delay the issuance of the writ of possession to buy yourself more time to move. Filing the appeal paperwork is the only way to delay the writ of possession. If Superior Court denies your appeal, you can appeal the denial to the Maine Supreme Court on issues of law or the judge using abuse of discretion, and only if there is a recording of the trial and/or appeal hearing. There is no legal right to directly appeal an eviction order to a federal court. Final thoughts. What if you do not go to the eviction hearing? If you do not go to the court hearing and your landlord does, you will lose. The judge will probably enter a default judgment against you, which will prevent you from filing any appeal of the order. The landlord can go back to court 7 days later and get a writ of possession and have you served that day by a deputy sheriff. Once you get served by deputy sheriff with a writ of possession, you have 48 hours to move. If you do not move within 48 hours after being served by sheriff with a writ of possession, the landlord can have you arrested and removed for criminal trespassing. If you owe the landlord money for rent or damages or other costs, he cannot get a court order for any money at the eviction hearing. He can only get an eviction order to force you to move. The landlord can sue you later, if he wants to, for any money you owe him for back rent, property damages, utility costs you were supposed to pay, court costs, attorney fees, and possibly future rent if he cannot rent out your unit reasonably quickly because of damage you or your guests may have caused. This presentation has been proudly presented by Maine Tenants Justice League. For more information, you can call us or text us at 207-358-8887. You can reach us on Skype at maine.tenants, or you can send us an email to help@mainetenants.org. Thank you very much for listening.